The arguments have been made and the votes are about to be cast. Let's talk right now about the top 3 reasons that the Senate should vote against the impeachment of Donald Trump. Make sure you watch the entire video to get all 3 of the reasons and a brief explanation about each one. But why am I talking about this? I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer and a legal and political commentator here on YouTube. If you like this type of content, if you like legal and political opinion analysis, news, and commentary, hit the subscribe button and the notification bell so you don't miss a video. Also, I have actually watched every single minute of the Senate impeachment trial. Every minute that they've done, I've watched it. And how can I prove this? Well, I live streamed all of it here on the channel. And if you watched along, you were able to see these types of reactions in real time. If you did not watch along, the replays are still up on this channel, and all of my live stream replays get uploaded to a Rekieta Law live channel. You can check them out for yourself. But the top 3 reasons are what's important. We're talking about hours and hours and hours of argument, and we can really distill it down into just a couple minutes, and that's what this video is for. First, it's unconstitutional, which is simultaneously a really important reason that it should be dismissed, but also a little bit more complicated because it comes with an asterisk. And let's talk about why that is. It mostly is because of where this power of impeachment is derived. That's from Article 1 and Article 2 of the United States Constitution, which basically give the full power to bring impeachments to the House of Representatives, meaning no one gets to tell them how they do this. The House decides to bring an impeachment by a majority vote. How they come about that vote and what goes into it isn't really questionable by anyone else. But the balance to that is that the sole power to try the impeachment goes to the Senate. And in a similar way, how the Senate conducts that trial is subject to very, very few restrictions. And all of those restrictions are in the Constitution specifically. And namely, that is when the president is sitting for the impeachment trial, he shall sit with the Chief Justice presiding and be entitled to the full Senate sitting in session. That's it. Other than that, how the Senate conducts the impeachment is really up to the rules of the Senate. The House doesn't get to decide, and most importantly, the Supreme Court doesn't get to come in and intervene. Now, why do I say that this is unconstitutional? We have a little bit of evidence for that, but why hasn't this been stopped if it's unconstitutional? I mean, it seems like if it's unconstitutional, someone would come in and stop this thing from happening. The evidence for why it's unconstitutional lies chiefly in 2 things. First, the president isn't the president anymore. He's now a private citizen. And we know this for the second reason that this is unconstitutional is because the Chief Justice is not presiding. These 2 things work symbiotically to bring about a strong argument that on its face, this impeachment is unconstitutional. If the president is impeached, the Chief Justice must preside. It says so right in the Constitution. It uses the word shall. Shall means must, not optional. If the Chief Justice is not presiding, then Donald Trump must not be the president. If Donald Trump is not the president and not sitting for trial as the president, then he's sitting for trial as a private citizen. And we don't have the power to impeach a private citizen. Now, during the debates, the House managers actually tried to make the argument that Congress should have the power to impeach private citizens. They tried to mitigate this, but they didn't actually make the argument that they're only trying this private citizen because he's a former president. But that's not where the extent of their argument goes. And it stands to reason, based on what they presented, that they believe the opposite is true, that they believe that Congress has the power to impeach any private citizen. And the reason I say this is because their citations for why we should be able to do this go back to William Hastings' impeachment, which was in England. Now, in England, they could actually impeach private citizens, and their impeachment was not limited in punishment to removal from office and disqualification like ours is. They necessarily couldn't be because you could impeach private citizens. They also mentioned that several states at the time of the drafting and adoption of the Constitution allowed the impeachment of private citizens at the state level. While that is true, that doesn't actually play into their argument. We have plenty of Supreme Court precedent that says that every word added to or omitted from the Constitution was intentionally done so, and you cannot read inferences into the Constitution about what should be in there based on the time. Now, you can take an originalist approach and look at what the definition of words are, what the common understanding of the meaning is, and Scalia has always been a champion of that. But you cannot add or subtract words, clauses, or powers in the Constitution. This is really a terrible argument from Jamie Raskin, who is apparently, or was, I should say, a constitutional law professor. He should know better than this. But you're not allowed to read into the Constitution the power to impeach private citizens because it existed at the time. In fact, it goes the opposite way. Since it existed at the time in both England and in the early states, we can confidently say that the framers were well aware, since many of them would be from those states, were well aware of the constitutional ability of the states and the UK to go ahead and impeach and try private citizens. And they chose not to put that in the Constitution. And because we have plenty of Supreme Court precedent around this, we know that their omission of this power was intentional. The Supreme Court has told us so over and over again. Since it's intentional that they did not include the power to impeach private citizens, we cannot sit in judgment over a private citizen. Now, the House's argument also comes down to the idea that Donald Trump was impeached while he was still in office, therefore, he was impeached properly. This is actually not so clear as they make it out to be because they refused to deliver the articles of impeachment to the Senate prior to Inauguration Day, which means when they delivered the articles of impeachment, Donald Trump was no longer in office. So we now have an unanswered constitutional question of whether or not he was president at the time he was impeached, because we don't actually know definitively when the impeachment attaches. Does it attach when it's made, when it's voted on in the House, or does it attach when it's delivered to the Senate? In theory, according to the House manager's argument, and this was never fully fleshed out by the defense, and I think they could have spent a few minutes talking about it. They don't really need to. But in theory, the House could vote to impeach someone and never deliver the articles to the Senate, and they would be impeached forever. Now imagine this. Imagine you impeach. You just make a vote to impeach in the House and never deliver the articles to the Senate and hold on to that impeachment for as long as you want. In fact, you could impeach every single political opponent that you have. If one party gains the majority in the House, they could spend their time impeaching every single person on the other side. And then they could just hold those articles of impeachment, wait for them to leave office or run again or whatever, and then they could bring the impeachment. They could hold it over as a sword of Damocles over the person and decide to withhold the actual service of the impeachment to the Senate forever. Imagine if they waited 20 years to impeach someone. Under the House manager's theory, they can do this, and this goes against all notions of process that exist in any sort of court. So with all of this talk about unconstitutionality, we go back to the question, why didn't anyone stop it? Remember how I said the Senate has the sole power to try impeachments? There isn't a way for the Supreme Court to really step in and stop the Senate from having their trial, even if it is unconstitutional. That remedy would only be reserved for Donald Trump if he were convicted on impeachment. Then he would have the ability to petition the Supreme Court to review it and find it unconstitutional and to try and undo it. Although if this would actually work is an open question. That's why the Senate must vote. They must vote to acquit, and they can use the unconstitutionality as a reason for that vote. There is no rescue because it's a plenary power to try the impeachment given by the Constitution. There isn't someone who gets to ride in and quote unquote save the day. That's why. So let's move on. Which brings us to part number 2. There was no due process afforded to President Donald Trump or his defense team, and that is the second reason that this should be dismissed. The issue of due process flows directly from and simultaneously feeds back into the ultimate question of constitutionality that we just discussed. And that's because your right to due process is guaranteed by the Fifth Amendment of the Constitution whenever essential liberty is at stake. And essential liberty is at stake here. It's Donald Trump's liberty, his right to attain public office. This is something that the government can't just take away from you. There have to be specific and narrow circumstances surrounding the reasons that you are disqualified. Lack of citizenship, for example. Lack of presence in the United States at all. Loyalty to a foreign power. The support of rebellion against the United States, and impeachment and removal from office, and disqualification to hold future office. Those things have to happen before you can be deprived of your right to hold office. If you don't fit into any of the narrow categories, then you have a right. They are trying to take that right away from Donald Trump, which means he should be afforded process, and he was not. Due process itself is an encapsulation of this idea of essential law and justice. These principles that make law and justice, or that are law and justice, make the legitimacy of a court. Without those principles and protections, you have a kangaroo court, not a court of any legitimacy. And it's easy to see where those essential notions were not present in this trial. First of all, there is no presumption of innocence for Donald Trump in these proceedings. Nothing at all lends the idea that he is presumed innocent. In fact, Jamie Raskin, the lead House impeachment manager, treated this entirely as a civil affair, not any sort of criminal affair. But the analog for impeachment is much more akin to criminality than it is to a civil matter, because you have an accused who is accused of a high crime and misdemeanor. You necessarily are closer to criminality than you are to a civil matter. And Jamie Raskin ignores this. In fact, he even argues against it. And he argues against it both implicitly and explicitly. But it really came on the final day of argument when he said that Donald Trump needed to come in and present under oath testimony. Otherwise, the Senate could draw a negative inference about his absence. That is not present in any way in criminal court, and it's simply not something that you get to do. You don't get to draw a negative inference because you cannot be compelled to testify against yourself. And that was what they were trying to do. Force Donald Trump to testify in a way that they believed would be damning to him. But that's not how the accusatory process works. The accusatory process requires the prosecutor to present a case, not for the defense to justify behavior without the prosecution making the case in the first place. The accusation is not evidence of a crime. And that issue of evidence is pretty important because while they demanded Donald Trump come in and offer under oath testimony on his own behalf, they didn't offer any under oath testimony or signed affidavits or testimony under penalty of perjury. They didn't have any interrogatories. They had no subpoenas. There were no rules of evidence for the House managers at all. These rules of evidence are not some fluffy concept that has no teeth or meaning. They exist to protect the process, the sanctity of law and justice. They exist to prevent a kangaroo court from occurring. You have the right to review evidence. You have the right to confront your accusers. Those accusers must speak under oath. Those accusers must speak. And the House managers didn't bring anyone to speak. They offered testimony, but that testimony would be called hearsay in any competent court. They didn't have any exceptions to the hearsay. They had no protections for the evidence that they brought against Donald Trump. And most importantly, they were called out on it by Mike Lee. But that's not the only problem. The other problem stems from an issue that was pointed out by Schoen, one of the attorneys for Donald Trump. And he did an exquisite job of doing this. Yes, I said it. He showed how the House impeachment managers manufactured, created, doctored screenshots of tweets that Donald Trump is supposed to have made. You can't manufacture evidence against an accused. In any criminal case, as pointed out by Michael Vanderveen, once you doctor evidence, not just criminal court, I should say, criminal and civil court, once you doctor evidence and are caught doing it, your case is done. It's over. You lose. You don't get to do that. But House Manager Jamie Raskin not only doctored tweets that are attributed to Donald Trump, he brazenly and bravely did it during a photo op from the New York Times. It was out in the open that they did this. This is how ridiculous this impeachment process is. There is no due process afforded to Donald Trump. So again, with the same asterisk as before, because ultimately no one can come in and stop this proceeding, the Senate should vote to acquit based on the lack of due process afforded to Donald Trump, because anyone sitting in a similar seat should be and would demand the same due process. And finally, on to that third issue, he didn't actually incite anything. The issue of whether or not Donald Trump actually incited insurrection, even though I saved it for last, is just as important as the other two. In fact, all three of these issues work together. This isn't a ranking. They work together as to why Donald Trump should not be convicted for incitement to insurrection. Okay? He shouldn't be convicted because it's unconstitutional, there was no due process, and he didn't do it. All of those things combined. Now, House Manager Jamie Raskin tried to create a standard of incitement to insurrection by a president that doesn't exist anywhere else. But the actual legal standard for incitement has existed for a very long time, at least going back to the 1950s with a case called Brandenburg versus Ohio, and more recently solidified by a case called Bible Believers, which happened in 2015. Now, these things ultimately lay out a test. These two cases create a test for whether or not speech is incitement and can therefore be punished. Importantly, the first prong of this test is where the House managers actually fail, and they fail critically here. The speech itself, the speech in question, must actually incite the unlawful activity. It must ask for it. It must, in some way, demand or request a person do the unlawful thing. Incitement is a heat of the moment sort of thing, a speech to whip a crowd into a frenzy and get them to do an unlawful thing. That's how incitement works, and thus, the speech itself must actually whip them into the frenzy and have them act, ask them to act. It typically needs to do so explicitly, although there is a theoretical implicit way to do it, but that implicit question must still exist. And the problem that the House managers have is that Donald Trump never actually asked anyone to do anything illegal. He asked them to do only legally protected activities, walking to the Capitol, not going inside, raising a peaceful protest to make their voices heard. And though he said fight like hell, he was never ever telling the crowd to engage in violence. He never used it in a way that suggested that peaceful protesters could engage in violent behavior with their voices causing physical harm. Those are incongruent positions. They don't mesh. Ultimately, Donald Trump's speech never once asks anyone to do anything illegal or violent in any way. And that is the problem with the House manager's case. And this was hammered home by Bruce Castor, who, after a very disappointing opening day, did much, much better, even though he is like Ambien to listen to. He's got a very slow and methodical speaking cadence that can be a little boring, but his legal arguments were absolutely on point. They also briefed this really well, but he delivered on the final day a very good oral argument that went back to that brief. And ultimately, the Democrat House managers failed to show wherever Donald Trump ever asked anyone to do anything unlawful. And this is a critically important element of incitement. Otherwise, you could simply say when anything that was undesirable happened after someone spoke, you could attribute it to that speech, even if it had nothing to do with that speech at all. Because you could say, well, they created this thing by secret messages. That doesn't work. The speech in question must actually incite. Now, the House managers presented a lot of evidence that Donald Trump asked people to be in Washington, D.C. on January 6th. And he certainly did. There's nothing illegal about being in Washington, D.C. I think people probably know this. Although many criminals may reside in that Capitol building, there is nothing actually illegal about being present in the city or asking people to come to the city. There's nothing illegal about asking people to go to the Capitol building. Now, you can't enter the Capitol building while Congress is in session, and many people who did have been arrested and charged. I think there are well over 200 charges now. So those people will have trials to see if they are convicted for what they did. That's a separate issue. Donald Trump never asked anyone to go in the Capitol. Donald Trump never asked anyone to cross a barrier or to touch or harm a police officer. In fact, there's plenty of evidence to suggest that he asked people to engage in only lawful activity that was specifically peaceful and to respect law enforcement. That's the big problem for the House managers. The second prong of incitement is you have to intend for the result to occur. You have to not only ask for the result, but you have to reasonably intend and anticipate that the result will occur. Incitement's an intent crime. Someone who gets up and says something but doesn't have any desire to drive someone to unlawful activity can't be guilty of driving someone to unlawful activity because the predicate act was the other person's willful desire to act, not act at the urging of the speaker. The speaker must intend and urge someone to go ahead and engage in the unlawful behavior. The Democrats, again, showed nothing of this. They had no witness testimony. They didn't have Trump answer an interrogatory. They never did anything to get any information on the record that Donald Trump intended the Capitol riot to occur. And with just a basic look at it, the Capitol riot did him no favors. There would be no logical reason for the Capitol riot to benefit Donald Trump in any way. There's lots of reason to think that having people stand peacefully outside and raise a vocal but peaceful protest would benefit Donald Trump. It's good optics. It's good messaging. Congress can actually hear you. It may change the opinion of a certain Republican or senator or House member. It may fortify their resolve, something he asked the crowd to do. Go help them be strong, he said. The second they cross the police line and cause chaos that disrupts the House session, all benefit to Donald Trump goes away. So it's hard to make a case that he would necessarily think that this was a good thing. They would need to show some specific reason why it would benefit Donald Trump and why he intended to achieve that benefit. They failed to do so. And finally, the results must have been reasonably imminent. So that imminence factor is a problem as well. Those results must have been foreseeable and imminent, not just intended. They have to be foreseeable that they would actually occur. And that imminence is a real problem because by the timeline provided by the House managers, people had already crossed the Capitol barrier line prior to Donald Trump's speech ending, and his speech was 1.5 miles away. It takes about 30 minutes to walk 1.5 miles for a normal person. Because of this, it's hard to suggest that he incited activity that was occurring before he was done talking. In fact, they couldn't even link. Now, they could maybe try and get around this by saying he was broadcasting by video and that his words were being said prior to people entering and people left his speech and had time to get there after he said a certain phrase, but they didn't actually do that. And part of this is their ultimate rush to impeach Donald Trump. They didn't go through the process of gathering evidence in an investigative and thorough way, and then compiling that evidence allowing the defense to challenge and refine that evidence and to ultimately come up with a factual record that they could argue from. They failed to do this. Now, I think while I say all this, I think number 3 was the strongest point that they made. I think they made a case that this could have been foreseeable and that this was potentially something that could happen. But that prong doesn't matter. And I'm not saying they made a great case. I just think it's the best one that they made. That prong doesn't matter if they didn't ask for it and if they didn't intend it to occur. So on this issue, they should vote to acquit because Donald Trump's speech does not meet the legal definition for incitement. As a counter-argument, the House managers literally said the legal standards and the Constitution don't matter in this impeachment. And that, my friends, is enough for me to say that no matter what else they argued, Donald Trump should not be convicted on this impeachment. If the Constitution doesn't matter, then we don't have a country. But tell me what you think. Drop a comment down below. I hope you found this video insightful. And if you did, like, subscribe, share, all that stuff. Talk to you soon. Peace. Peace.